In this lecture, I will discuss the topic of abatement of the suit because of non-impeding the legal heirs of the deceased defendant. But in this topic, we are considering the case of several defendants, and one of them died, and therefore there is abatement only against the deceased defendant, and it is not the abatement of the whole suit. So I am discussing the lecture series on the topic of bringing of legal heirs on record. So far, with respect to this topic, I have delivered by 3 part of video lectures. First part is relating to introduction of all legal provisions under the Civil Procedure Code relating to bringing of legal representative of deceased party in suit. Second lecture is relating to limitation period provided under Articles 120 and 121 of the Limitation Act, and third lecture is relating to limitation period provided under Article 137 of the Limitation Act. And now this is the fourth lecture relating to topic of bringing legal representative of deceased party in a suit, especially deceased defendant. Now I will discuss this topic with the help of one reported case law, reported judgment. Judgment is given by the Honorable Supreme Court of India, and this citation of this reported case is All India Reporter, year 2004, Supreme Court, page 3942. What are the facts of this case? This judgment is given by the Supreme Court in civil appeal. The facts of this case is that this case is relating to the family of Muslim persons. So there is one Muslim person, his name is Isa, and he died, and his wife and children, they have filed one suit. In the year 1979. So plaintiffs are the wife and children of one person whose name is Isa. Those plaintiffs filed suit in the year 1979. They filed a suit for the possession of 7 rooms. Those 7 rooms are upon one plot, and description of that plot is given in Schedule A to the plaintiff, and particular description of all those 7 rooms are described in Schedule B to the plaintiff. So this is a suit for recovery for possession of those 7 rooms. According to the plaintiffs, that property, that is a plot which is described in Schedule A to the plaintiff, it was a self-acquired property of that person named Isa, who died on 8 January 1970. So it was the contention of the wife and children of that Isa, who are plaintiffs here, that property described in Schedule A plot, it is a self-acquired property of Isa. On the contrary, the defendants in this suit, they are the other heirs of the father of that said Isa, whose name is Musa. So defendants in this suit are the other heirs of the father of that Isa, whose name is Musa Sai. So defendant contended that this said property, it is not self-acquired property of the Isa, but it belonged to the all heirs of the Musa Sahib, who is the father of Isa. So particularly defendants number 1 to 4 are the other heirs of that Musa Sahib in this suit. Defendants number 1 to 4. So the defendants allege that suit property belongs to all the heirs of Musa Sahib, and therefore they denied that the suit property was self-acquired property of Isa. Isa is the son of Musa Sahib. It was the contention of these defendants number 1 to 4 that the suit property was the property of the heirs of Musa Sahib as a tenants in common, and therefore it is not exclusive property of the deceased Isa. Here, this concept of tenants in common, it is opposite, exactly opposite to the concept of joint tenancy, and concept of joint tenancy is equivalent to co-parcenary, concept of co-parcenary under the Hindu law. So concept of joint tenancy and co-parcenary, concept of this joint tenancy and co-parcenary or joint property and co-parcenary, it is not there in the Muslim law. So there is nothing like a joint tenancy or co-parcenary under the Muslim law. So here all the heirs of the deceased ancestor holds the property, then they holds the property as a tenants in common. So in case of tenants in common, the ownership of each one of the heir is already specific, it is ascertained, and there is nothing like undivided interest or share in case of Muslim law, but in case of co-parcenary, each co-parcener is having undivided share or interest in the joint property of their joint family. So until the partition is effected in case of Hindus, in case of co-parcenary, each co-parcener is having undivided share or interest in the co-parcenary property, but such thing is not there in case of Muslim law. So in case of Muslim heirs hold the property as a tenants in common. So in case of Hindus, when one of the co-parceners file a suit for the partition of co-parcenary property against other co-parcener, such thing do not happen in case of Muslim. There is no suit for partition of innocent joint family in case of Muslim persons. So in this case, those defendants number 1 to 4, they claim that property belongs to all heirs of Musa Sahib as tenants in common, and they also contended that those defendants number 1 to 4, that they have perfected their title ownership also by adverse possession, because they have been in possession of those 7 rooms for more than 12 years period. Furthermore, it is also disclosed by the defendant that the defendant number 4 had let out the portion of 1 room to the defendant number 5. He is not member of that family. So defendant number 4 has let out the portion of room in his possession to one defendant number 5 on rent basis. Then trial court framed the issues. However, when that suit was pending before the trial court, that defendant number 4 died on 8 May 1987. Now in this case, it is a duty of the plaintiff to make an application before the court under order 22 rule 4 for bringing the legal representative of that deceased defendant number 4 within the limitation period of 90 days from the date of the death of that defendant. But that plaintiff prayed for the extension of time for making such an application again and again. Therefore, the court, at the request of plaintiff, granted the time repeatedly to bring the legal representative of the poor defendant on record. But plaintiff ultimately fails to take steps to bring the legal representative of the deceased defendant number 4 on record. Therefore, ultimately, on 1st August 1987, the trial court recorded that as because the steps to bring the legal representative of deceased defendant number 4 on record have not been taken by the plaintiff, the suit against defendant number 4 alone shall stand abated. Trial court held that suit against defendant number 4 alone shall stand abated. The trial court also come to conclusion that suit property was the self-acquired property of the ISA, meaning thereby who are the plaintiffs, wife and children of that ISA, they are very well entitled to file this suit for the recovery of that property from the defendants because it was the self-acquired property of ISA. Trial court also dismissed the claim of defendants that they have perfected their title by of adverse possession. So, theory of adverse possession is rejected by the trial court. Therefore, trial court decreed the suit ultimately. Trial court decreed the suit for the recovery of 7 rooms particularly described in Schedule B to the plaintiff. Trial court decreed the suit on the basis of one map which is produced by the plaintiffs, which shows the entire property in Schedule A, that is plot, and those 7 rooms which is more particularly described in Schedule B. And that map shows that all those 7 rooms, it was in possession of, means particular rooms out of those 7 rooms are in the possession of each particular defendant. That means possession of each defendant over particular rooms are clear. Furthermore, it was admitted fact that deceased defendant number 4 had let out the room in his possession to defendant number 5 on rent basis. So it shows that defendant number 4 was occupying a separate room out of those 7 rooms. Therefore, trial court held that after the death of defendant number 4 and because of the failure of the plaintiff to bring on record the heirs of defendant number 4, the entire suit did not abate. Therefore, trial court decreed the suit only against the defendant numbers 1 to 3 and dismissed the suit against the deceased defendant number 4. So, suit is decreed against defendant number 1 to 3 and suit is dismissed against the deceased defendant number 4. So, trial court passed the decree on 28th November 1990. Now, suit is decreed. Therefore, those defendants number 1 to 3, they were aggrieved party. They filed the first appeal against such decree in the lower appellate court, that is a district judge, district court of district judge. And in that appeal, the district judge held that plaintiff had sought for a decree jointly against defendants number 1 to 4. So what is the finding of the district judge? Plaintiffs had sought for a decree jointly against all defendants number 1 to 4. Plaintiffs have not sought for decree against a particular defendant in respect of particular portion of the property, and therefore plaintiffs had sought for joint decrees against all the defendants, and therefore upon the death of defendant number 4, and because of the plaintiff's failure to take steps to bring legal representative of defendant number 4 on record, the entire suit stood abated. So what is the finding of the first appellate court of district judge? Entire suit stood abated. What the trial court held that entire suit did not abated. Suit is abated only against the deceased defendant number 4. First appellate court held that entire suit stood abated. Why? It was held by the district court. The interest of the defendants was joint interest, and therefore it was not possible to sue some of the defendants without the other. Therefore, that lower appellate court dismissed the entire suit as having been abated. And the appeal filed by the defendants number 1 to 3 was allowed by the district court, and decree passed by the trial court was set aside. Now against this judgment of the first appellate court of district judge, plaintiffs are aggrieved person. They have preferred appeal to the High Court. Now High Court in this appeal, High Court came to the conclusion that in the present case, as each of the defendants was in the separate independent possession of each of the rooms, this is a fact. Because of this fact, each of the defendants was in a separate independent possession of each of the rooms, the reliefs prayed for were divisible. So, what is the observation of the High Court? Plaintiff is seeking possession of particular room from particular defendant. Plaintiff is seeking possession of another particular room from another particular defendant. That means whatever relief is claimed by the plaintiffs, that relief is divisible. That relief is not joint, divisible, and therefore decree was enforceable separately against each of the defendants. So it is what could be the decree for recovery of possession? So how it could be enforceable? By recovery of possession of particular room from particular defendant. Therefore, this is the finding of the High Court. Therefore, the second appeal was allowed, and High Court restored the decree passed by the trial court, setting aside the judgment of the lower appellate court. So because of this judgment of the High Court, now who are the aggrieved person? Again those defendants number 1 to 3. Therefore, they have filed this present appeal before the Supreme Court. Now this matter accordingly came before the Supreme Court. So what is the view of Supreme Court in this matter then? Supreme Court said that they do not find any merit in this civil appeal, meaning thereby the order passed by the High Court is correct order. Why so? Why it was the view of the Supreme Court? Because that Schedule B to the plaintiff give detailed description of the suit property. Each of the 7 rooms has been marked on sketch, and it is tender in evidence. Besides, in the plaintiffs separately mentions the rooms in possession of each of the defendants in paragraph 5 of that plaint. Means plaintiff have mentioned that this particular room is in the possession of this particular defendant. Plaintiffs gave separate schedule to the plaint which describes the room in possession of each of the above defendants. Further, plaintiffs sought possession of each of the rooms separately from each of the defendant, while their pleadings in paragraph number 11 of the plaint. So, plaintiffs sought possession of each of the rooms separately from each of the defendants. So, taking into consideration all these facts, it is a view of the Supreme Court. It is a finding of the Supreme Court. Taking into consideration of all these facts and circumstances, the trial court was right in holding that the suit against defendant 4 alone stood dismissed as abated. So trial court was right. Suit against defendant number 4 alone stood dismissed as abated. Therefore, the trial court was right in declaring the suit of the plaintiffs only against the defendant number 1 to 3. It is the observation of the Supreme Court that what was the interest of the deceased defendant in a particular case, whether he represented the entire estate or only a specific part of it, it is a fact that will depend on the circumstances of each case. If the interest of the co-defendants are separate, as in case of co-owners, the suit will abate only as regards the particular interest of the deceased party, but the entire suit will not be abated. And therefore, ultimately, Supreme Court held that they do not find any merit in this civil appeal. Therefore, they have dismissed this civil appeal and uphold the judgment of the High Court, meaning thereby they uphold the initial decree passed by the trial court. So, in short, what has been stated, see, this is very important case because on this particular issue, this matter came before the Supreme Court. Means trial court passed the decree, then lower appellate court, that is court of district judge, matter went to then High Court and ultimately to Supreme Court. So, in short, Order 22 Rule 4 of Civil Procedure Code lays down that where within the time limited by law, no application is made to impede the legal representative of deceased defendant, then suit shall abate as against the deceased defendant. This rule does not provide that by omission to impede the legal representative of a defendant, the suit will abate as a whole. So this rule does not provide that by omission to impede the legal representative of deceased defendant, the suit will abate as a whole. What was the interest of the deceased defendant in the case? Whether he represented the entire interest or only a specific part, it is a fact that will depend on the circumstances of each case. If the interest of the co-defendants are separate, as in case of co-owners, then suit will abate only as regards the particular interest of the deceased party. So it is held by the Supreme Court. So I stop here. We will discuss some another topic relating to this main topic in our further part of the video lecture. Thank you.